My name is Mark Briscoe.
I'm Christian Osuna.
I'm JT Cabral. I'm Joshua.
And we did the sixth one, which was, how does the Eighth Amendment protect the rights of those accused of crimes both before trial and after conviction? What is the relationship of the rights protected by the Eighth Amendment and the natural rights philosophy? And how should decisions about bail, fines, and punishment be made, and by whom? Why? So, the Eighth Amendment states that the government cannot impose excessive bail and fines, and there cannot be any cruel and unusual punishment. Thus, through the Eighth Amendment, no matter your crime before the trial, you will have the right to bail and reasonable fines. Almost all cases, the accused is posted bail, but in a few cases, they're not. For example, United States versus Salerno. Salerno was obviously proven to be part of organized crime, and the judge refused him bail due to him being unsafe on the streets. And so after the defendant is convicted, the Eighth Amendment protects him from any cruel and unusual punishment, meaning any punishment that is disproportionate to the level of the conviction. For example, in the court case Weems versus United States, Paul Weems was he worked at the Bureau of Coast Guard and Transportation and was convicted for falsifying documents. He was subjected to 15 years of imprisonment with hard labor. Later, the Supreme Court reversed the sentence because it was too severe according to his crime.
Before a sentence is carried out during a federal criminal case, the jury needs to decide whether the accused is guilty or innocent. If found guilty, the judge schedules a date for the sentence hearing. The judges themselves determine the severity of the sentence and if they deserve bail or not. They have obtained this power to determine the punishment of a criminal by their respective state government and are considered the most trustworthy person in a trial. However, under Federal Rule of Criminal Procedure 32A, before imposing a sentence, the court must afford a counsel an opportunity to speak on behalf of the defendant. During that time, the defendant can present any information that has not been mentioned to possibly reduce the harshness of the sentence. They are given this opportunity for the reason of giving their point of view on the crime committed, and given enough evidence, the judge might make the sentence more forgiving. On the contrary, any victims or survivor of the victim can suggest more leniency or strictness in the sentence. Depending on the situation, the victim or the victim's family can claim that this case had caused them unimaginable suffering, or they could be more understanding of the innocence or the reason for their action and ask for a less cruel verdict. When deciding the sentence, judges must bear in mind if the offender is a first-time offender or a repeat offender, whether or not they were the main offender, if the crime was harmful or violent, and if it was by purpose or accident. In addition, fines can be issued if a law is violated in places under surveillance of police officers. For example, on freeways, drivers are given warnings with signs about maximum and minimum fines regarding the violation of a certain law, such as slowing down or moving over for the safety of road workers.
There are boundaries that distinguish a crime. These are an individual's amendment rights and an individual's natural rights. A natural right is considered the rights to a human that a human obtains from being born into society. Amendment rights being the rights that are listed within the Constitution. Natural rights originated from the philosopher John Locke in the 19th century. The concept still applies to today's society in some concepts. In the Declaration of Independence, Benjamin Franklin bases some of his views from the words of John Locke. His famous saying, "Life, liberty, and the pursuit of happiness," is based off the views of John Locke. There are resemblances between the natural rights and the Eighth Amendment, but finding their occurrence where they coincide is difficult to find. The Eighth Amendment prohibits the government to post excessive bail, excessive fines, and the use of cruel and unusual punishments. First, when judges make a decision on how much a criminal's bail should be set at, they have to refer to their instincts and inflict the proper amount. They would refer to the philosophy to make sure that they are reasonably punished for the crimes, and there's no system for these decisions. The other resemblance between the philosophy and the amendment is focused on the cruel and unusual punishment of the Eighth Amendment. When a person has a chance to make a decision on how an individual should be punished, they again refer to the natural rights philosophy. They don't want to inflict a cruel and unusual punishment just basing off of how they think a human should be treated. John Locke's views on life should be treated right and still connect to certain instances.
So answering our question in the big picture, the Eighth Amendment used to protect people from unreasonable fines or bails and protects one from unusual crime punishments. An example is what Christian said about the minimum traffic fines. And then this is also explained in the example of U.S. versus Celerano, or the U.S. versus Weems case. In the court of law, the jury decides the future of the accused, and the hearing is scheduled and finished. The judge decides the punishment for the guilty offender. The defendant then has an opportunity to speak and reduce the severity. This is proven in the Article 32A under the Federal Rule of Criminal Procedure Code. The relationship between the rights protected by the Eighth Amendment and the natural rights is that the Eighth Amendment rights serves to protect one's natural rights, and natural rights is determined the harshness of the offender's punishment depending on the charges. The severity is determined by a judge referring to natural rights, and then it is also natural rights at the same time.
Okay, thank you. Questions? All right, so you guys mentioned that the judge determines the severity of the punishment, correct?
Yes.
Do you guys think that this is fair?
Well,
Oh yeah, so what we've been watching in class, Stephen Avery, like in that case, the judge could obviously have bias and stuff like that against the defendants, like in Stephen Avery's case, and in that case, then it's not fair at all because he was automatically like pretty much convicted before even having a chance.
and also when he was sentenced to jail, he was given without bail.
Choosing the right judge is also a job that has been done correctly, so that there's no bias involved.
So just like when you pick jury members, you guys think that the judge should also go through some type of screening? Should there be a standard on bails? Okay, so for example, you commit a crime. Whatever that crime is, should there be a minimum and a maximum on bails?
Well, I think there should be a minimum on a bail because if, for example, on a murder, that would be like a very high bail, whereas a theft would be less than that.
I also think the bail should be determined by how many offenses they have as well, so there shouldn't be a minimum or maximum depending on what crime they did.
There should be like a thin guideline on how they should be setting the bail. If it's more serious, you should keep it high, but without going too high. It's just basing off of what the judge's instincts at this point, and there should be some exterior influence on how they are going to be setting bail when they're convicting.
So is it ever fair to not allow bail? To say you're staying in jail, no bail will be able to get you out?
Well, yes, because like in cases where people repeat like serious crimes over and over again, I think that they should stay in jail instead of like releasing it to the public because it's like they're like what do you call that?
They don't deserve the privilege anymore because
of like roaming the streets. It's dangerous.
Okay. All right, thanks guys.
Wait,
Oh.
Robert has a question.
Sorry, Robin.
Do you think that there's ever any bias based on the accused arrested person's socioeconomic status on the amount of their bail? Like, if someone's rich, do you think it's fair to set their bail higher since they're more likely to pay?
it wouldn't be fair, but I think it's determined by the judge, and I don't think the judge knows the economic status of these people.
Well, there is times when there's celebrities and like athletes that are being convicted, and I've noticed when I'm watching the news or something like that, their bail is set a little higher because they know that the athlete or actor or any famous person has a large amount of money, and the bail might be set a little higher because they know they can make that bail. A lot of athletes make bail because they just have the money for it. So a judge may be biased against that, or towards that.
All right, thanks guys.